So welcome everybody to another episode of Law After Lunch. Today I'm happy to introduce Guido Alfio Grasso from the University Catania in Sicily, Italy. And Guido is a professor there. He's also a lecturer, of course. He has been a lecturer at other universities too. Before Catania, he was a lecturer at the University of Milano. And he was also, or is, a fellow at the Weizenbaum Institute at Humboldt University Berlin. He is doing a lot of research in private law, but also focuses on topics that are very topical, like surrogacy and artificial intelligence. And today he's going to talk to us about a topic like that, artificial intelligence, which is very timely because, as you all might know, the EU rulemaker is about to set a legal infrastructure in place. And we are very interested and happy to have you with us, Guido Alfio. And you have the floor now. And happy to hear your presentation. Thank you so much.
Thank you very much. Thank you, Anne. Thank you all. I'm okay here, okay? Thank you very much. First of all, I want just to apologize because I speak in English. And you know that I understand, I study Deutsch and I speak a bit, but you know that for Italian lawyers, and especially the lawyers that study private law and criminal law, also Roman law, it's very important to know German and to have the ability to read German, at least to understand the most important in a textbook. So I'm very happy to be here, and when a scholar tries to arrive at a certain point in your career in university, is just, we can say, a mandatory passage that to spend a period of time in Germany for an Italian private law. So I had this opportunity at Humboldt and at the Weizenbaum 2-3 years ago for 3-4 months, and so I am very happy to come back when I have the possibility. So today we speak about the AI Liability Directive and its legal economic implications. We'll see. We focus before on the current debate among EU law on these on the implication, legal economic implication of the liability of the AI liability perspective, and then we see 2 or 3 the most important things about this liability directive. Just a quick introduction, but some brief introduction about artificial intelligence. I like to focus and I like to highlight, first of all, the positive outcomes of artificial intelligence. You know that there are more scholars, some scholars are optimistic, other ones are more just not very happy, not very fan of artificial intelligence. I'm collocating myself on the first part of this debate. I'm quite optimistic, and so I like to see more the positive outcomes than the negative one. And artificial intelligence has proven to be very able to produce positive outcomes in terms of speediness, in terms of accuracy, and especially in decision making. Also, these positive results, these positive outcomes. On the other part of the coin, we have some liability issues, because these instruments are very accurate, but at the same time they can generate very unprecedented injury and damages. This development opens up a whole series of new questions related to liability with respect to damage caused by artificial intelligence. Who is responsible in the causal chain of damage? The manufacturer, the developer, the user? What is the concrete determination of the percentage of risk? Who bears the burden of proof? The liability directive focuses specifically on the burden of proof. We'll see at the end of this talk that the liability directive focuses on this point. This is the most touched point upon by the AI liability directive. For this reason, some scholars think that is not enough, but there is also a problem of European legislative competencies. We'll see then that we all know that the European Union has no jurisdiction on our civil law liability rules. That depends on our national systems, and our national systems differs a lot one from the other on this point. We see that we have more or less the French and the Italian system that is atypical, and the German one and all the affiliation of the German one that is more typical and more close. So for the European Union legislator, this was just a mandatory, in a certain way, a mandatory choice. The debate in Europe among scholars, which began after the American debate, revolves around two different approaches. For some scholars, artificial intelligence device cannot be treated like other ones, just the electronic ones, just the devices we knew, and that's like an object. So we must be given subjectivity, at least partial subjectivity. Very illustrious scholars argue and support this thesis. Illustrious German scholars support this thesis, and this position has been considered also by the European Parliament, so it has gone beyond the pages of our books, the conference we met, and arrived at the European Parliament. But treating artificial intelligence devices as autonomous subject means that rules imputing liability to the employer for damages produced by its employees cannot be applied. This is just an example, but if we prefer this line, and if we recognize personhood to the autonomous system, this is just one of the most evident consequences, because we cannot apply this type of rule, all the rules that impute the responsibility, the liability to the employer for the act committed by the employees to the artificial intelligence devices. This stance is based on a high concept of artificial intelligence, and perhaps for the upcoming innovation it will face, and especially the ability of this system to communicate, to intercommunicate, and to make autonomous decision on its own. However, constructing a legal personality more or less reductive, more or less strict, might just be a way to overcome, to bypass, to way around the problem, because and this is usually scholars who argue or support this thesis draw a parallelism between the condition of slaves in Roman law. But the problem is that slaves in Roman law, removing this aberrant fictio iuris, this pretension that pretends that linked them to objects, they remain human beings. They were human beings, so were themselves human beings. A robot, even if based on an AI system, remains a robot. So without autonomous ratio decidendi, rationale, and feelings. And this word feelings in our discussion is not so common, but we have to focus on it, because feelings, our decision, is also a fruit of feelings that we don't know yet perfectly why, and we feel, but a robot, and also the most important research about this topic, exclude that a robot can feel something autonomously. Even if they are very complex, even if they are very accurate, very precise, they remain a robot, and they remain devices programmed by a human being that decide to recognize, that instructs them to recognize a face from an image, to recognize a disease from a medical image, and so on. Moreover, my opinion, if we modify our personality system, we risk setting a precedent that can be very dangerous. As a counter-argument, other scholars say that we have yet applied this pretense, this fictio juris of person, of attribute a subjectivity to a corporation. No? We consider a corporation, an association, as human being, juridically, legally as human being, and we treat them as such. But the problem is that we face another type of problem respect of the corporation and the personhood of a corporation. In the case of a corporation, and we consider them a legal person, just to limit or to exclude the responsibility, the liability of the participants in the corporation. So we exclude joint and several liability of the participants. In our field of discussion, we face a different problem, is to identify and to make that someone pay for the damages an AI system may create. So in this case also, and for this reason I use the word before, that if we introduce a personhood for the artificial intelligence system, maybe it's just a way to not to resolve the problem, but to way around it, because the problem to attack, if we attach a legal personality to intelligent devices, the problem become, in that case, how to form the assets to cover and the liability for the damage they cause. And if we take again the example of the slave in the Roman law, they were human beings, so they were able to pay autonomously if we take away these fictio juris, these aberrant fictio juris. In the case of the robot, they are unable to do it. So in any case, we need to, the problem in that case will be how and who cover this asset, and maybe in that situation we use mechanisms that we all know, just the insurance one, or other that we all know from the company law. So in any case, mechanisms that we don't need a specific subjectivity, a specific status to resolve the problem we face. And also for the reason the European Union legislator decided to abandon this idea at the moment, and instead add new regulatory rules or amend the existing ones. The European legislator is going both ways, and add new rules and amending the existing ones. We all know that there is a very important process of innovation in Brussels about this context. Just 2-3 lines about what our country are doing. Some countries have already adapted the rules to the new arrangements. Also taking account of what I said before, that the liability rules are a matter of national law, not a matter of European law. So this is also why the directive has a scope of application very short. Let us think of the rules that in our legal system control and govern the liability for the act, for the reaction, for the action of animals, or the liability rules that govern the road traffic damages, or the rules that govern the ruin of buildings. No? If there is the ruin of buildings and then an accident happens and there is a problem of liability. These rules can be modified, can be amended to the new scenarios. And in some states, in some countries like Germany for the road traffic damage, haven't been yet done. Of course, and now you understand better what I said before, this mechanism, this possibility depends on our national liability system, if it's typical or atypical, makes the difference because in whether national rules can be adapted by supplementary interpretation, by the jurisprudence or the doctrine, or we need a specific discipline legislation. Our Italian, or like the French one, is an open system, so we can recognize indemnization, compensation also without a specific rule, because we have a general provision, 2043 of our civil code, so we mutuate from the French code. So in this case, our courts and our doctrine can adapt by the supplementary interpretation of these rules to the new scenarios, to the new context, to the new damages. What is less certain is that we can adapt the liability rules for dangerous activities. We have specific rules about dangerous activities, just the nuclear, imagine when we nuclear or electric products and so on. In this case, because statistics tell us that instead the eye devices reduce the risk of harm. So I don't see this just the best way forward to adapt our rules. The European Union instead, within its competencies, has moved in two different directions, which some colleagues, which some important scholars have called confusing. First of all, adapting and renewing the 1985 producer liability rules, and second, introducing new and specific provision on artificial intelligence devices. For their part, these new rules about artificial intelligence devices are divided between two different rules. We have, and this is the difference between the EU AI Act and the EU Liability Act. We have rules about safety to prevent damages, to prevent the possibility that damages occurs, the occurrence of damages, and the liability rules. The directive I'll talk in 5 minutes about to deal with the conflict that can arise when a damage, when a damage eventually, nevertheless, occurs. Why the producer liability directive is not fine to face this new type of damages? Just 2 or 3 points about the existing liability directive and why it's not well suited to this new type of damages. It does not extend to services, and it is questionable whether a software it is a services or a good. So I just say, so some scholars say that we can apply it also to services, but the many other scholars say the opposite. So if we agree that this directive is impossible to apply to services and software are services, so the manufacturer would only be liable if the software is embedded in a good, so embodied, we use this word, but often these devices, like the one I studied more, like the diagnostics devices, the diagnostic devices, the diagnostic decision support devices, are apps, so are applications. So the doctor, the physician, use this app in the computer and put the index, the ins, and then there is the result. So there is no non-embodied in a physical instrument. Second point, the manufacturer responds if there is a defect. The most important point of the directive is the defectiveness of the product, but it is not necessarily the case that every type of damages produced by an AI devices, it is defective, this device. So sometimes the AI devices can produce that damages, but they are not in se defective. They are good, they have not are defective, but at the same time they can produce a damage. Third point, in any case, the adaptability of these devices, so the capacity of these devices, of AI devices, to adapt to the circumstances, makes it possible that the device manifests its defectiveness later than the good was placed on the market. We all know that the defect must be there from the moment the good, from the beginning, from the moment the good was placed in the market, for the manufacturer to be liable. This is quite not in certain point, because other scholars say that also with the provision that we have now, AI, the defect that an AI device can manifest later, the moment it was introduced to the market, can be covered by our current rules. In addition, we all know that there is the state-of-art defense mechanism. If a defect was not technically possible to foresee at the moment the product was put on the market, the manufacturer is not liable for it. And since we are talking about a sector where the innovation is so fast, we face there is the risk that this defense mechanism in favor of the manufacturer applies often. All these points and others lead to the consideration of and led to the consideration of other avenues, of other solutions, and first and foremost the strengthening the safety requirements of AI devices, so introducing new and specific rules. And this is what the European legislature has done with the proposed April 2021 AI regulation, the so-called AI Act. The Commission proposal takes a preventive stance on damages and seeking to prevent it, and at the same time the goal is to balance the protection of fundamental rights and without hampering the socio-economic benefits of AI. The Commission identified 4 levels of risk, each referring to certain AI devices and certain AI application. There is a long list because there is an annex where there are all these very analytic legislation, and the Commission consider unacceptable risk and therefore prohibited where it is unacceptable. The risk, the device and the application is prohibited. When AI is applied to those artificial intelligence systems considered a threat to security. I just can do a very easy example. For example, this category includes applications that manipulate human behavior to circumvent the free will of the user. Voice-assisted toys that encourage minors to behave dangerously. These are prohibited, completely prohibited, absolutely prohibited. The Commission instead includes in the threshold of high risk those systems and technologies of AI entrusted with the preservation and implementation of certain fundamental rights. It's just a difficult statement. Just when we apply AI devices in sensitive infrastructure, imagine access to credit, access to health system, our care system, public credit services, bank services. In this case, this type of devices are put in the high risk category. They are permitted, but they face strong requirements before they have to respect some strong requirements to be put before they put on the market. And because they concern sensitive infrastructure related to our human value. Thirdly, a limited risk is assigned to those systems such as chatbots that can give rise to error related to erroneous awareness in the individual if we are speaking with a machine, with a chatbot, or with a human being. Unclear whether the interaction is with a machine rather than a physical person. Finally, a minimal risk is associated with AI applications that are not as invasive as to the other one. Imagine the spam filter in our email. So a high level of risk is associated with different and most important and most stringent and most restrictive compliance rules prior to placing the device or application on the EU market. But even the European legislator, even the European lawmaker could not have been so optimistic to set aside, to abandon the idea of introduce liability rules that regulates what happens ex post facto after an incident, a damage occurs, deriving from an AI device. So we have preventive rules and ex post rules, ex ante rules and ex post rules, just in case, nevertheless, just in case a damage occurs, in case these requirements, although these requirements would have been respected, a damage occurred. In this case, the European legislator introduced this type of rules. So next to the AI Act, it brings in a second piece of legislation in case when damage occurs resulting from an AI device. This is the AI Liability Directive. The AI Liability Directive, which is based on a mechanism of cross-reference to the AI Act. If we cannot understand well the AI Liability Directive, if we don't know exactly what the AI Act states, because they are very related, they are very there are mechanisms of cross-reference among them. The AI Liability Directive has a scope, and I anticipate that can be and appear very limited. As a scope that is, but it's a scope that is as narrow as it is crucial, because it concerns the disclosure of evidence concerning AI devices suspected of having produced harm, and the possibility of alleviating the burden of proof on the victim of such harm. These are the two points touched upon by the AI Liability Directive. So disclosure of the evidence concerning an AI device that it's likely produce a damage, and then the possibility of alleviating or facilitating the burden of proof of the victim of such harm. So, first of all, a presumption of breach of a duty of care is introduced when the provider, imagine the manufacturer or the user or a user of a high-risk artificial intelligence system, refuses to comply with a court order to disclose or preserve evidence available to it. So, these presumptions, in my opinion, seems to be welcome, because in light of the reluctance of the difficulty to obtain information and to obtain elements of proof when we face a judiciary contentious by AI liability claim, in practice, this reluctance of the providers and users to disclose information and to reveal items that can be helpful to prove a damage regarding artificial intelligence system is due not so much to technical shortcomings, to technical impossibility, not often, but as to a desire to not reveal business logic, not reveal profit, and to profit maximizing perspective. So in this case, I think this is a good aspect of the directive, because it's very difficult to understand the mechanism of an AI devices for the opacity, but also because the company in general try to avoid to respond analytically to the demand of information, to have elements that can be very helpful in front of a judge to prove the liability of also the link, the causation between the damage and the product. And I use the word causation because more doubting is the second presumption. The second presumption is related to the existence of causation. It's important to add that the existence of causation, all the aspects related to if there is a causation, if there is not, are matters of our national law systems and differs from each other. So we have different rules, and the European legislator cannot add specific rules of maximum harmonization on this point. So it's just a minimum harmonization, also because we have different rules and the European legislature has no jurisdiction on this point. These are a bit more difficult, but I'll be short some words just to highlight the most important point. This presumption applies to damages produced by artificial intelligence systems, apparently, but if other scholars think the opposite, apparently limited to physical damages. However, in general, the presumption applies to damages produced by artificial intelligence systems. However, when it comes, and this type of presumption works when the injured party proves a certain number of evidence, a certain number of elements. So this presumption trigger when, and just in case, the victim, the injured party, is able to prove certain element and give some evidence. However, this is the point, when it comes to high-risk artificial intelligence system, because this type of presumption can be applied also to non-high-risk system, artificial intelligence system, but when it comes to high-risk artificial intelligence system, the object of proof narrows, and as far as non-compliance is concerned, is reduced to proof that the provider has failed to comply with one of the requirements to which is subject under the proposed regulation, AI Act, so here we see the cross-reference, or that the user imagine a physician, the physician is a user when he uses an AI device, or the user has failed to comply with the obligation to use or monitor the system in accordance with the instruction received image from the manufacturer, or where appropriate to suspend or discontinue its use, or has exposed the system to the input of irrelevant input data under its control. So, if this latter requirement, imagine a physician that exposed the system to input that are irrelevant, a physician that instruct the system with index of a disease, misleading the system because enter input in a program, digital box, that can be traced back to another pathology, thereby misleading the system. So if this latter requirement, irrelevant input system, irrelevant input data, is properly within the user control, and so as such is demandable to the user, The same user often finds himself in the position of being unable to comply with the obligation to use or monitor or suspend the system in accordance with the instruction received by the manufacturer, without thereby generating damages for which he could be liable under national liability provision. So the point is, sometimes the operator, and we'll see in the operator, in receiving ambiguous or imprecise instruction from the manufacturer, or antinomian instruction respect to the case brought to his attention. In this case, the user should comply with them in order to avoid the risk of triggering the reversal of the burden of proof under the directive. Because the directive says you have to respect the instruction. If you don't respect the instruction, there is the triggering, the result is triggering, the risk of triggering the reversal of the burden of proof. At the same time, because just for this case, I use this expression between a rock and a hard place. If or she does what his or expertise suggests, he or she risks leading to the reversal of proof because he or she disregarded the product's information, instruction. If, on the other hand, the operator, imagine a doctor, I use the example of a physician because I know more the reality of a physician and doctor. If, on the other hand, the operator follows the manufacturer's instructions, he or she risks being held responsible as a law expert, as a poor expert under his or her national law. So for this reason, the operator, sometimes the user, is between a rock and a hard place, triggering the reversal of the burden of proof, or risk to be held liable for poor, because considered a poor expert in his expertise under his or her own national law. Despite Article 14 is the paragraph 4D of the proposed regulation, the AI Act provides that the operator often must be in a position to orient himself by following only his expertise. In reality, sometimes the operator is not in that situation. Sometimes the operator is not in a position to orient himself by following just his expertise. Just 2 points about economic analysis of law, because it's very important, and also because it's in the context of our meeting. If the use of artificial intelligence is to be encouraged, without limiting, without running the risk of disabling the human-in-the-loop principle. We all know what human-in-the-loop principle means, and we see this principle in the AI Act and in all the most important regulatory texts on AI. If we don't want to discourage, if we want to encourage the artificial intelligence innovation without disabling this principle, it is necessary, in my opinion, to avoid basing intervention of liability, tighten the burden of proof on the pure causation, on the bare causation. We have to limit the punitive response just in cases when we can, when there is a serious reproach can be addressed to that operator, to that user, so on the level of the subjective imputation. So we don't need just to focus our response on pure causation, but we need and we must limit our approach when, in front of the user when the user behaved in a fault-based. This notation, and we will finish, allow me to say something about the economic analysis of law around this proposed directive. So, if we agree that artificial intelligence has shown to be a very important way to reduce the risk of error, specific in medicine and in other fields. And if we agree that can be a benefit and can produce immediate benefit to the population. And we agree that we want to facilitate these technologies and their use. In this case, private law rules can play an important role. Private law rules can play an important role because the economic analysis of law show us and teach us that law is not just a defensive mechanism for regulating conflicts, but also is a tool that we can enhance to encourage the action of the individual and the promotion of values and the promotion of activity, and at the same time to discourage activity that we want to discourage, to disincentivize. Their purpose then is to balance remedial and compensatory tools to the promotion of the AI liabilities, to the AI systems, and also because in order not to discourage the practitioner, I use also this example of physicians, because I know many practitioners, many physicians that are scared to use AI devices because they don't know very well if a damage occurs, what level of responsibility or level of liability they have, and so they are quite scared to use these AI devices. Imagine when a radiologist relies on image analysis software to solve a sophisticated image interpretation problems using AI. He or she is referring to a very extremely sophisticated system and is placing high expectation of the finding of this system. Expectation that must be taken into account when we analyzing the percentage of liability. In this regard, the liability provision and the flexibility that characterize them, because the liability provision, the private provision, private law has on its side, respect to the public law, the flexibility. So we have this very important thing that is the flexibility that public lawyers and public scholars are unable to have, because they work with strict rules and quite impossible to shape. So we have this problem we have this characteristic of flexibility that we have to strengthen and to move on this heavily. Indeed, shifting some of the liability or all of the liability from the user to the manufacturer or the developer. Well, there is the difference because big back-end operator, front-end operator, these are notions that we know. There is also, we can really encourage a physician and user in general to use these tools by also increasing their confidence in the use of these systems. Through a liability system that takes into account the peculiarities of these instruments, their high accuracy, interoperability, autonomy, and at the same time the investment of trust and competence that the qualified user have made in them, it is possible to build a legal economic environment that is not only fairer, and just I make an example, because the manufacturer is often, it's quite evident, the most economically solvent party. So for a victim, for an injured party, will be easier to obtain compensation or full compensation from a manufacturer than from a user, even from the help of an insurance company. So in this case, we can create not just a more fairer system, but also a system more virtuous, because it fosters experimentation and especially the commercialization of technology, advanced software that can be very useful for the promotion and the enhancement of our health and of our human values. Thank you.
Thank you very much, dear Guido,
thank you.
for this insightful intervention. Now we have time for a quick Q&A session, if you agree, because sure. I think there are some questions about your intervention, and I invite the audience to pose them now.
Sorry if I overstayed.
Brief question. You have mentioned that we have to shift the liability from the user to the producer, but it doesn't mean that it, and you have mentioned also that producer usually is a more solvent party, or let's say player in the field. This must not be the case at all. If we have a front-end developer, which are usually small enterprises, for instance, we have a ChatGPT and front-end developer which develops a small tool, small specific tool for very narrow field on the one side for doctors, and then we have a huge clinic which apply this tool, and then we have an insurance company. And at the end we have a small developing company which is sitting somewhere in Ireland and have nothing behind. We have just shifted all the risks, and at the end the person injured had nothing. Maybe, just a scenario, but just... That's the first question, and the second question, just if I may.
No.
The second question is also with regard to the general approach of the EU regulator to the issue. So the approach is, so we don't want to look at the AI as the person, that's for sure. But what is more disturbing for me is the point that at least in my understanding, the EU didn't want to realize that this is for the first time in history that we are dealing with a cognitive process outside of a human being. Yeah, this is for the first time we are regulating a cognitive process which is taking place artificially, but it is a cognitivity. And for sure it's not on the level of human, but it means on the one side, it's not, I would say in a different way, it's not in the breadth of the human being, but it has intensity is much higher than by the human being. So different capacities of AI are much higher than the human being. So we are dealing with a completely different legal material, I would say, yeah, legal subject, and we don't want to accept that. This is my approach. So we still deal with the issues slave or not slave, I don't know, a mechanical thing like a nuclear power plant, which for sure has risks, for sure. But the point is behind that nuclear power plant has no cognitive activities at all, which we have here with that result. What do you think on that?
I agree. For the question, I agree. For I start from this one. I agree. I just maybe some scholars said, and maybe this can be something that match with your question, that the EU legislator decided to introduce regulation. I can propose just that maybe a solution is to introduce different piece of legislation. Depends on the level of AI. Just not one piece of legislation for every time of AI, but different piece of legislation depend on the AI level. And another important thing, and this I think is a fault of lawyers and our approach, maybe we are too, more in Italy, I don't know, in Germany exactly, my colleague, I don't know very well how they work, but, and now we are trying to work more in teams, with engineering, with informatics, because we suffer this approach very a bit dogmatic, a bit focused just in our way of see the world, so in our structure. So maybe we don't know very well all the aspects of the cognitive process that they are moving in the world. I agree with you about this point. And I think that you approach sometimes the European legislator maybe in this just pressure to stay not behind the Europe, the America, the USA innovation, the China innovation. Maybe this can be a problem that we introduce norms, rules, just the GDPR that in this moment the GDPR we introduced in 2016 entered, and now we try to modify it in 5-6 years. Just another process of modifying it is actually debating in Brussels. So about the first question, it's a very good question. Also the first one, because when we speak in general, we have to. I think that the one by one situation, consider the different situation, is very important. This because if we have, but in this case, more than the front end developer, I thought to the back end operator, a manufacturer considered as a back end operator. But I understand that for a startup, for a little company, but I measure just the most important one, just a big one. A small one, in this case, can be difficult to imagine a situation where all the responsibility, the liability shift to this company, to this small company, and a big clinical, a big hospital remain outside from the responsibility, the liability. But in general, more than the different situation, the point is shift liability to the manufacturer, to the developer, can be a way to can be more just, because the hospital or the physician that use an instrument has not the possibility to change it, to make it better. Just use it. If used in a good way, is not responsible. We can apply a fault-based principle, a fault-based approach, because I'm in general contrary to strict liability approach, because in general I think we had to use the strict liability approach just to exception, just to it's not just in the, I don't like it, because strict liability approach means that behind a strict liability approach there is a punitive concept that is extraneous to the private law rules. So, but the problem of one piece of legislation, and consider all the different situations in one piece of legislation, is that we treat the small company just the biggest one. So we treat the most important company, and we treat the front-end developer of a small company as the front-end operator of the most important one. So also, and I close, this approach, very analytical approach of the European legislator in this moment is good, because give foreseeability, because we can prevent the situation. But the problem is that the flexibility, the GDPR is based on the accountability principle. This accountability principle that some scholars criticized a lot, but has on its side the flexibility. You know that if you are the responsible of the treatment, of the processing, you must put in place the rules, and you decide more or less the level of the safety, because you know your company, you know the risk, and so on. And so the flexibility. This analytical approach, we don't have flexibility. We have a level of risk. We treat all the things as the same. We have enormous category. All the medical devices are high risk. All the medical devices, also just the smallest one can be. So, and the AI Act abandoned this flexibility approach, this accountability approach. Maybe this can be, but the information I read before today was that the AI Act in the end of the year, in 2023, or maybe the first part of 24, enter into force. Will enter into force. So we don't have enough time to change in 6 months. But the AI liability directive, we have space to debate and to try to change something about this directive. The debate among scholars on this directive, I checked it yesterday, is just is arising, but in the next month we'll see more about this, because the directive is of September, October. So thank you.
Thank you. All right. I think we have another question, and we have a question in the chat, I think. Yeah.
Okay, you gave a rather optimistic approach on AI and AI liability, but what about the risks, especially the data loss risks? For example, Italy was the first and only country in the EU to prohibit ChatGPT, also because of the risk of data loss in the United States. So from data loss, sensitive data loss, there can also derive like some damages, severe damages in the economical sphere can derive. So what's your position on that? And is this addressed in the directive? Is this considered? Like,
no,
what about the risk?
Thank you very much. At this point, the problem in this case, in my opinion, is that we have different pieces of legislation that overlaps a bit. We have the GDPR about data. We have the new privacy regulation. This is a proposal, but maybe next year will enter into force, or at the end of the year. This AI liability directive, the AI Act, the new product liability directive. I don't speak about it. I didn't speak about it today, but there is also this new liability about producer. So all these different pieces of legislation bring new problems, and they overlaps. In Italy, the problem with this maybe in this case, and I agree with some scholars that think about it, is a bit confusing, the approach of European legislator, because we have 4 or 5 pieces of legislation, 2 enter yet into force, 2 or 3 that in the forthcoming will enter into force, that treat more or less the same problem. Very, very long text of legislation. So with a lot of provisions that we need to connect and to understand the differences. Just the problem with the ChatGPT in Italy is that the Italian authority of data private resolve this problem just asking for just applying a rule that we all know, that is the consent. So consent that you agree to the use of this data and so on. So the problem is that we use rules and we use instruments that we use in the past for problems that we had for centuries. But now maybe they are just, I don't say useless, but they don't fit very well to the problem we have now. Because we use tools and figures, imagine in our law study, that maybe in this situation reveal their limit, reveal their defectiveness, their shortcomings. So just now ChatGPT is now freely usable in Italy. We can use it, and it's possible to use. Just it's a month ago they started to use it. So I know, because I saw a video about the possibility to use. And now they ask you the consent to take your writings, email, just to extract, to feed the system, to replicate your way of writing, your thought in a more or less way, your way of saying something. So they can write an email, they can write a text, using your data. But this is more or less the approach. Italy is quite was very this was a polemic about this suspension of the ChatGPT. Someone thought was too strict, other thought was correct. So we are go across this for 2 or 3 months. We debate a lot about this problem.
Okay, thank you very much. Do we have time for one more question?
Yeah, I have a rather short question from the chat. Yeah, these are 2 questions, but I think they belong together. So, did the Commission lay out what AI developments they want to incentivize and which they want to hinder? And adding to that, and do we have some objective assessment of what AI might benefit society and what AI is dangerous about?
This is a very good question. So, the objective assessment is a very important point. We have statistics, we have some objective assessment in a way of saying it, because we know, I speak about medical field because I know better. We know that sometimes the diagnostic decision support system maybe helps the physician to identify the correct disease and then to treat this, or the radiologist. We have all these enormous field of discussion about the radiologist. Radionomic is all this field of medicine where the AI liability, where AI is helping a lot physicians. There are also risks. Risks, in my opinion, are more the skilling of the human being. So the human being is just knowing that there is a system that can replace or they can help the physician, but I use this as just an example, in a way of saying lost just control, lost just competencies. So that we name it the skilling because, and just more or less the problem of ChatGPT. Imagine a text, or that you don't need to write it, but you have a machine that can do it for you. So in 5-10 years, you will lose this capacity to write a test or to identify a disease on your own, without an instrument, without a technical instrument. This is a problem. It's not a second one. The incentivizing the of the AI system. Now, in the AI liability directive, or just in all these EU texts, we have a long series of principles, of values, when we the promotion of human being, the promotion of human values, and so more or less the idea that we have to incentivize all the systems that enhance the human value and to enter the other one. But the problem is that the same instrument can be a way to enhance the human health and to damage the human health. So it's not just so easy to put a line between instruments that are good and instruments that are bad. Just if we think about the example of the toy that say something bad to convince a person to act badly, this is clearly a bad instrument. But if we consider all the other one, it's more difficult to understand, because if it's the way we use it, the way this instrument has been fed, because it's just an element. No? We use this word feed this instrument that instruct the instruments. And also when all these passages are good, because the developer acts in a good way, the device is good without defect. Also in this case, we can have a product and devices that produce damages, harm people. So I suggest always an approach more analytically, more with precaution and with the attention to the case, just the way we thought before, not the way we talked about to differentiate the situation, because we cannot speak in general. We can make mistakes if we do just a big picture. No? Thank you.
Thank you very much, dear Guido, again for your intervention. And yeah, I think we could talk about this even longer, but the session has come to an end.
Thank you for having me here, and I'm very happy to be here. And I stay the afternoon, I visit the Halle, so I'm very happy. Thank you.
So great. Thanks again.